Christine Steele, and I'm a Public Trustee representative for the Office of the Public Guardian and Trustee. I'm pleased to welcome you to this session of the Office of the Public Guardian and Trustee Learning Series for 2016. This webcast is part of the Human Services Learning Series, a joint initiative from the Government of Alberta's Human Services Department. Today's session is focused on discussing the role of the Office of the Public Guardian and Trustee in the administration of the estates of deceased persons. I have a background in legal services, and I'm currently working in the Deceased Estate Administration section of the Office of the Public Guardian and Trustee. I manage a large caseload of estate administration files, collecting information, applying for court authority to administer estates, and distributing funds to beneficiaries. We will have an opportunity to answer some of your questions at the end of this presentation, so please type them into the chat if you have any. Once again, thank you for attending today's session. The role of the Public Trustee. In 1949, the Public Trustee Act was enacted. That legislation created the Office of the Public Trustee for the province of Alberta, and with updates since then, continues to provide the authority for the Public Trustee to act to protect and administer the property of vulnerable Albertans. For 63 years, the Office of the Public Trustee was part of the Ministry of Justice, and it's now a division of the Provincial Ministry of Human Services. The Public Guardian and Trustee provides support and services to vulnerable Albertans by protecting and advocating for individuals who are unable to make personal and financial decisions for themselves, by providing legal guardianship to represented adults making decisions regarding health care, where to live, with whom to associate, social activities, education, employment, and non-financial legal proceedings. By administering the property of represented adults, minor children, and deceased persons, and by providing information, education, and support to the public, private guardians, and private trustees. Our vision is to create a province where all Albertans can achieve personal autonomy, live with dignity, and maximize their potential. The Office of the Public Guardian and Trustee will work with others to provide excellent, proactive, timely, and respectful service to vulnerable children, adults, and families of deceased Albertans, and to all Albertans. A personal representative or executor is a person who has the legal authority to deal with a deceased person's estate. When preparing a will, anyone can name the public trustee as the executor or personal representative of their estate, though the public trustee may not administer every estate where they are named as personal representative. The public trustee has the same right to renounce administration of an estate as any other named PR or personal representative. If the public trustee is named as the PR, the person making the will should advise our office and provide us with a copy of the will. The public trustee may act as a personal representative when there is a minor who is a beneficiary or an adult person who requires a trustee. When the public trustee is their court-ordered trustee, that is, and that person is a beneficiary of the estate. We may also act in the case where no will can be found, there's no known family, and no one else who can take action. If there are no minors with an interest in the estate and no represented adults with an interest in the estate, we may renounce and allow someone else to administer that estate. If all of the beneficiaries request that one of the beneficiaries act as a personal representative instead of our office, we would renounce to that family member. We will not act as a co-executor of a deceased person's estate. If there is no will, the public trustee is not automatically involved. The public trustee often receives referrals from the medical examiner's office or hospitals and long-term care facilities, friends of the deceased, or other family members. Anyone can make a referral to the public trustee to administer an estate, though we may not take on every estate. We regularly receive calls from people advising that their loved one died and they had no will, and they wonder if our office will automatically administer that estate. If there is no will and there's no vulnerable Albertan who has an interest in that estate, the public trustee will not likely administer that estate. In order to determine if we should become involved, we gather information from a number of sources. If a person has more debts than money and property, then the public trustee will not administer this estate, even if there is a minor or a represented adult beneficiary. For example, if a person dies and they owe more money than they own, and the public trustee is trustee for the deceased's only remaining kin, or there are minor children involved, the public trustee will take no steps to administer the deceased's estate, as there would be nothing to gain for that minor or represented adult client. At times we receive calls where a person dies and they have a low income and perhaps an older vehicle and very few other belongings. Perhaps they have a small bank account and lots of credit card debt and other debt, but they have 3 minor children. This is a case where the public trustee would not administer the estate, as at the end of the day there would be nothing left for the children to benefit from. If the family is unknown, the public trustee may take steps to identify family members. If necessary, the public trustee may enter a deceased person's residence to look for a will or information about their next of kin. Section 12 of the Public Trustee Act gives our office the authority to enter a deceased person's residence and take possession of their property for safekeeping. So what happens when the public trustee receives a new referral? During the initial stages, the public trustee will look for a will and information such as greeting cards or correspondence or address books that may lead us to family contact information. We may also look for life insurance policies with named beneficiaries, banking information, credit cards, sources of income, income taxes, those kinds of things. And we can do research to identify and locate parents, siblings, spouses, and children. We can send inquiries to banks and financial institutions to ask about bank balances and investments and securities, and also debts. If the public trustee finds a will with a named personal representative, that person has the first authority to make funeral arrangements and administer the estate. If there is no will and we find family, the public trustee will not advise the family of death. We will provide their contact information to the funeral home or medical examiner or the police or hospital staff. Once the family is notified, it is their responsibility to make the final arrangements and administer the estate. We once had a referral from the medical examiner's office for a retired fellow who died all alone in his apartment. He'd lived there for probably 15 years, but he had very, very few acquaintances and no known relatives. He'd never mentioned any parents or siblings or spouse or children to any of the other residents or to the apartment manager. When we entered his suite and while we were there, we found an insurance policy that named his wife as the beneficiary, and her full address was provided. We did a Canada 411 search, and we found that his wife still resided in the same house, and her contact information was then provided to the medical examiner's office, and they advised her of his death. She then contacted me, and she told me that 20 years ago, he had faked his own death and left her and their 3 small children, believing him to be dead. They had never divorced, and she still had a valid will that named her as executor and her as a beneficiary. And due to the nature of the laws at that time, she was able to complete all of his final funeral arrangements and administer his estate. The Surrogate Rules of Court list potential applicants who can administer an estate in order of who has the preference. It is highly recommended that a named personal representative or person with preference seek legal advice to assist him in the administration of the estate. The public trustee cannot provide you with legal advice. Lawyer referral is a service provided by the Law Society. A lawyer referral operator will answer your call and give you names and telephone numbers of up to 3 lawyers practicing in the area of law that would best suit your needs. The toll-free number and website will be provided at the end of this presentation if you would like more information. After seeking legal advice, you may wish to administer the estate yourself. You can get the appropriate forms from the Queen's printer. Of course, before making a decision as to whether the public trustee will administer an estate or become involved, we will review all of the factors to ensure that there's no need for our further involvement. At times, our office will receive a referral and the deceased does have no will, no parents or no siblings, no spouse, no partner, and no children, and no family can be found. Our office will make necessary arrangements for their burial with a funeral home. There are a number of different funeral homes that work with the public trustee in such cases. In most cases, our office cannot approve a cremation for a deceased person. The only time we're able to approve a cremation would be in situations where there's no will and there's no family, but the deceased had made prepaid arrangements for a cremation, or there is a will and the will directs that his body be cremated. In such cases, the funeral home does still require someone in authority to approve those final arrangements, and our office does have the authority to provide that approval. We also may make arrangements for a funeral to be paid from a deceased person's bank account directly. If the deceased has no money to pay for their funeral, an Alberta Supports funeral will be arranged by our office. Alberta Supports funerals are very simple graveside services, and there's no reception or lunch to follow. If that deceased estate is entitled to the CPP death benefits, Alberta Supports will claim the death benefits to help offset their costs. In cases where there is a will with a named personal representative or there are family members who refuse to take any steps, out of respect for the deceased and in order to ensure each person has dignity in death, our office will make the funeral arrangements. Recently, we had a referral where someone died and our office and the police had completed extensive searches for family. We had information about a sibling in another province, though that sibling must have moved as the number that we had been disconnected. This situation was dealt with in an urgent matter, and in order to maintain the dignity of that person, even though all leads for family were exhausted, we proceeded with a funeral. Eventually, the sibling did get a hold of us, and we provided them with the contact information for the funeral home so they knew where their loved one was buried. The public trustee will not administer an estate where there is a named personal representative, a family member who simply refuses to take steps, unless there's a vulnerable Albertan with an interest in the estate, which means there's a minor who's a dependent or a represented adult who is a beneficiary of the estate. We once received a referral from the medical examiner's office. Our initial inquiries showed that This person had well over $60,000 in investments and securities and bank accounts, and he was the sole owner of his home, and he had virtually no debt. A will was discovered in the safety deposit box that named his son as the personal representative and his daughter as both were beneficiaries. His son refused to take any action. Both the son and the daughter were over 18 and they had full capacity to make decisions. Our office took no steps and didn't administer the estate, as there were no vulnerable Albertans that would benefit. Eventually, the daughter did step in and she retained a lawyer to help her probate the will and administer the estate. The public trustee will not administer an estate to resolve disputes between family members. The public trustee is not responsible for monitoring the administration of estates with outside personal representatives, either named in a will or with a family member who steps in to administer the estate. In situations such as the one that I described earlier, if there was a dispute between the two children, our office would not become involved to step in and resolve these disputes. We once received a referral where a person died and his friends didn't know anything about his family. They'd known that deceased person for 15 years and that person never spoke of any family. When we were searching through some of his belongings, we found a labor union card and we called the labor union. Fortunately, that labor union was able to provide us with family contact information, and we then provided that contact information to the funeral home. We once had a client who died with dementia, and this client had been a represented adult who needed a trustee to assist him when he was living, and his intake referral notes indicated he had been married in another province and had 3 children but was divorced from his wife. We followed up and we found divorce papers that had been filed in another province, but it set out the names of his 3 children. So we did some extensive research and we were able to locate his 3 children. The public trustee will take initial steps to secure homes and vehicles and document contents of homes and vehicles if we are going to administer an estate. We'll arrange for the appropriate insurance coverage and for the payment of the utilities. We'll remove the personal effects in a timely manner, items both sentimental and of monetary value. And we will follow up to confirm assets such as bank accounts, investments, life insurance, securities. And we will follow up to confirm debts or liabilities such as mortgages, credit cards, lines of credits, and personal loan. As I mentioned, we will place insurance on the property and arrange for someone to check on any vacant property. We'll make sure the grass is cut, the snow is shoveled, and the utilities are paid. We apply for life insurance proceeds or pension benefits that are payable to an estate. We may also call in life insurance, pension, or other benefits on behalf of a minor. We do have an income tax department that deals with filing income taxes on behalf of our estates. We follow up on all of the investments and bank accounts, and we ensure that all the debts are paid. We follow up on foreign pensions. And we will identify and locate beneficiaries. We had a situation once where this person named Anna died, and she was never married. She had 1 child who died before her, and that child was an adult who had 3 children. So these were her grandchildren, and they were all under 18. This is a situation where the public trustee may step in and administer her estate on behalf of her grandchildren as the beneficiaries. Another situation, this fellow named Joe dies. And Joe was married to Martha, and she died before him, and Joe and Martha had 2 children. Let's call them Adam and Eve. Adam is an adult who has a brain injury, and the public trustee is his court-appointed trustee. After Joe's wife died, Joe fathered another child, Stephen, and Stephen is a minor. All 3 of Joe's children are beneficiaries of his estate, Adam and Stephen are the vulnerable Albertans, so the public trustee would likely take steps to administer an estate such as this one. In rare cases, we'll administer an estate where not all of the beneficiaries are known. For example, let's say the public trustee acts as trustee for 2 adult clients, Mary and her sister Joan. Mary and Joan are twins who have significant disabilities, and they were both born in Germany. They immigrated to Canada with their mother when they were young adults and were both awarded large sums of money that resulted from a lawsuit. The public trustee confirmed that both of the parents are dead now, and Mary and Joan have 2 half-siblings through their father that they've heard about, though they've never met them, and they know their names and believe that these siblings still remain in Germany. Mary dies, sadly, and Joan and all of the half-siblings are now beneficiaries of the estate. Our office would administer Mary's estate in order to protect Joan's interest, and we would take steps to identify and locate all of those half-siblings that remain in Germany. We might retain a genealogical researcher or an heir locator to assist us. If ultimately we were unable to locate those half-siblings in Germany, their portion of the estate may be paid to the government of Alberta after appropriate notices and timelines are met. If estate funds are paid to the government of Alberta, they can be recalled if the beneficiaries are eventually located. We once administered an estate for a person, and we'll call him Thomas. We were unable to locate his beneficiaries despite our best interests. And we had forwarded all of the funds that we had been holding in the estate to the government of Alberta. And then years later, we administered another estate for a deceased person. We'll call him William. And William came from a very large family made up of siblings and half-siblings. And they all had the same mother, though their mother was predeceased. William and most of his siblings had been placed in foster care at a very, very young age. But after extensive research, we determined that Thomas was indeed a half-sibling of William, and Thomas's father had still been alive at the time of his death. Therefore, his estate was a beneficiary of his estate. Thomas's father had remarried and the wife was still alive, and so we made arrangements for all of the funds to be returned to our office with interest, and then the funds were eventually distributed to the rightful beneficiary of his estate. Every situation is unique and considered on a case-by-case basis. The public trustee cannot provide you with a legal advice. The public trustee can charge a fee to administer an estate pursuant to the Public Trustee Act. There's some contact information for you here on the screen. Our toll-free number is 1-877-427-4525. Our Edmonton number is 780-427-2744, and you can reach us in Calgary at 403-297-6541. There's some other information about our websites here.
Yeah, so we have a couple questions that have come in. Before I get to those questions, just point out to our viewers that if you have any additional questions, please type them into the chat that is below your viewing window. So our first question is, my brother died and he had no will. What should I do?
If your brother passes away and he has no will and he has no beneficiaries who are minors or who are a represented adult, I would recommend that you contact a lawyer and get some legal advice. As I mentioned before, the Law Society provides a free service called Legal Referral, and I would recommend that you contact them to get some legal advice before you proceed. If you decide to go ahead and administer that estate on your own without a lawyer, you can order documents from the Queen's Printer.
Our next question is, how are the OPT fees determined?
The OPGT fees are determined by a fee schedule that is set by our office. And I believe if you want more information about that, you can contact us, and we will see what we can provide for you.
Our next question is, my mom died and my brother is not doing anything with the administration. Does the public trustee monitor the administration? What should I do? Or what do I do?
That's a very good question. The public trustee does not monitor estate administration for other estates. That's up to the beneficiaries of the estate. If you do have a concern about an estate and you're a beneficiary and you're not sure that things are being handled properly, your best bet is to talk to a lawyer and get some legal advice.
Our next question is, if the public trustee is named as personal representative in a will and the estate ends up being insolvent, will the public trustee act?
No. The public trustee will not act in the case where an estate is insolvent. So that means that there are more debts owed than there are things that the person owned. A lot of times, the public trustee is named as a personal representative of the estate, but when we review all of the assets and all of the liabilities, the estate would be insolvent. No one would benefit from this, so we would not administer the estate.
Our next question is, would cremation be covered for a deceased person without a will?
That's a good question. Our office cannot, as I said, approve a cremation for a deceased person who doesn't have a will unless they made arrangements before they died with a funeral home to have their remains cremated.
And this is our last question. My brother died and I can't find his will. Does the public trustee have a copy?
The public trustee does not have a will registry. There's no will registry that I'm aware of in Alberta. The only time the public trustee would have a copy of someone's will or have information about that would be if that person named the public trustee as the personal representative. If you're aware that your brother maybe, bought some real estate and had a lawyer that acted for him or had some other legal issues that they were looking into, you might contact the lawyer that maybe represented him before to see if that lawyer would have a will. Thank you very much for joining me today. And I just want to remind you that today's webcast is part of the larger joint initiative by the Government of Alberta called the Human Services Learning Series. For more information about this series, check your emails for our regular updates or go to hslearningseries.ca. You can also follow us on Twitter at AB Human Services and with the hashtag OPGT. Again, thank you for attending today's presentation. Please continue to look for update on sessions from Employment First, the FASD Initiative, and ABII. Thank you.